everybody. We're so glad that you could join us on this beautiful Thursday afternoon. We have a great webcast put together for you. I know Julie's excited to talk to you guys about her favorite topic, which is wage garnishments. So without further ado, I'm going to turn the floor over to her so that she can answer the questions that you might have about this complex and interesting topic. All right, Julie, it's all yours.
Well, thank you very much, Jack. And again, good afternoon, everyone. Thank you for joining us this afternoon for our webcast. Everything you wanted to know about wage garnishments, but we're afraid to ask. Just a couple of real brief housekeeping notes before we get started. We will be recording this session and posting it out to our site probably within the next day or so. So if you have coworkers that were unable to attend today, or you yourself might need to depart early, we will have that out there so that you can then view it at a later time at your more convenience. We are also going to, for time's sake and respecting everyone's time this afternoon, we are not doing an actual question and answer session after our webcast today. However, if anyone does have any questions that they would like to receive an answer for, please include those in the chat box of your GoToWebinar menu. We will be compiling all of those questions after our presentation today, putting those answers together, and then sharing all of that out to all of you that have registered and attended today. Of course, if there's any other questions outside of that, you can always reach me direct here at TruPay through the Garnishment Services at TruPay.com email address. I have been here at TruPay now for coming up on 12 years. I, however, have been working in the garnishment world for a little over 25 years. So I've had the opportunity and chances to work in a lot of different avenues with these types of documents. The items that we're going to talk about today are really some of the more common ones that I get asked or I receive from people. And so that's kind of how we came up with our topics. I'm sure many of you will have additional ones. And again, please just include those in the chat box and we will be happy to address those for you. So without any further ado, let's just go ahead and get started. What is a garnishment? Well, a garnishment, by definition, is a court-ordered deduction. You are required to take money from your employee's check in some way, shape, or form based on the court order and how it is laid out. These are not optional. You do need to respond with them. As an employer, there are always certain obligations on your side that you need to participate in. Occasionally, that's just simply making sure the garnishment is set up against your employee for payroll deduction. Other times, there may be what are called interrogatories or garnishee answers. Those are documents that are looking for a little bit more information about your employees so that the court, the plaintiff, or the attorneys involved can determine what is going to be the best course of action to take. What happens if I do not respond to these? Well, the short answer is you're going to get another copy of it, and they're going to continue sending you a request for that information or continuing to send you the actual order itself. It's kind of like a baseball analogy. Third strike, you're out. As the employer, if you have received it 3 times and still have not responded or posted it for a payroll deduction, chances are very good the next one you get will be coming to you as the employer for the deduction, meaning that you are now being sought to pay off the debt of your employee. What are the most common types of garnishments? For those of you that have kind of been following me for the last couple of months with our garnishment communications we've been sending out, we have a document that is posted out onto our website that kind of talks about this topic itself. There are generally 7 types of garnishments that you could see. There are wage assignments, and you have both voluntary and involuntary. You have child supports, bankruptcies, tax liens, which are both federal and state, and then you have garnishments themselves, or judgments as they're also known as. Those types of items are ones where you have individual parties that are not a government entity, in most cases, suing somebody else. Are all garnishments public record? No, they are not. All child supports, even if they are part of a divorce decree, by law are private and redacted, so you cannot see the information through public record requests. And if you were to go onto the various websites that states sponsor to look up public records, you will not see the child support order there. The states are very, very restrictive of that. They are very high in the confidentiality of it because there are always minor children involved, and there's a lot more information on those child support orders than you are generally going to see on a regular garnishment of any sort. How do I determine if my employee makes enough money to collect for the garnishment? Well, there's a couple different ways you can handle that. Those of you that are a client of TruPay, our softwares are designed that as long as the deduction is set up correctly, it actually does the work for you. But it is always best practice to just simply verify that before you submit your payroll. And the reason you want to do that is you want to make sure that the correct and full amount needed is actually coming out. Now, the simple part of it is you simply take your employee's gross wages, and that is everything that they're going to receive. It can be anything from their standard regular wages, vacation, bereavement, auto allowances, things like that. It does not include employer memo items like a 401k match, but any of those gross earnings. And then you simply take and subtract the taxes. And that is just simply the employee taxes that are being calculated for the paycheck. Federal and state withholding, Social Security and Medicare, and where applicable, any kind of county or locality taxes. That gives you the bottom line amount of earnings that you have to work with to determine if your employee can be withheld for that deduction. We call those disposable earnings. If you receive an item or you receive an interrogatory and you have questions about it, you're not quite sure what information they're asking you for, I'll be very honest, some of those interrogatories are definitely worded a little bit crazy. But what you always want to do is, if in doubt, don't try to guess on it. Just simply call the entity that issued it. You will always have a contact, name, department, phone number, email, address, something of that sort. They are required by law to put that on those orders. You want to reach out to that source to get better clarification of how to handle those items. If it's something such as a child support, you actually have two avenues in which to reach out to. Most child support orders on the last page of the order will spell out to you as the employer what your contact location and who you should call for information or assistance. And a lot of times on the first page of the order, towards the top where it's already identifying the state that's issued the order, it will also list the county or locality that is handling that account. You can always reach out to them for assistance as well. What do I do if I receive a court order and my employee already has one in place? Well, it kind of depends on what's currently in place for them. Child support orders, no matter when they come in, always take first priority. All other orders that you may receive on your employee, it's really kind of like who came in first, who came in second, with the exception of federal tax liens. Federal tax liens always take second position, and then everything after that, again, follows in the order of priority in which you received it. If you have an employee that currently has a garnishment and you're being told to take 25% of their wages, well, another order, unless it's a child support, you're not going to be able to collect anything for it because federal law mandates you can never take more than 25% on those types of orders. Now, some states, and again, you'll want to check with the state that's issuing it or the state that you're located in, do have their own state laws which would supersede the federal law. Kansas, as an example, is one that every garnishment an employee receives is to get an equal share of that 25%. So what that means is that employee, heaven help us all, could have 25 garnishments and all of them are going to get 1% of the eligible earnings. State tax liens work a little bit differently. So you want to really read the document that you've received to fully understand how you need to treat it. And again, if you're not sure of how to handle it, just simply call the entity that issued it. How many court orders can I collect on from my employee at one time? Is there an order of priority for collecting on more than one order? So just as I mentioned, the amount that you can have really is determined by the types that you have. There are no limits on child supports. So therefore, you can have, in my personal experience, I've had employees with as many as 16 child support orders at one time. Each and every one of those, no matter who the state is, no matter when it was submitted to you for deduction, needs to be set up in your payroll system and deduction needs to be attempted for it. If they're garnishments, and it specifically states on there 25%, 10%, 15%, so on and so forth, you'll just simply want to pay attention to what the first one has and then determine if you can even set up another one to collect for it. Tax liens, again, the tax lien paperwork, whether it's federal or state, will guide you and tell you whether or not you can set up anything else at that point in time for collection. Bankruptcies, you're never going to have more than one bankruptcy at a time. It's against federal law. Now, you may have one bankruptcy. Generally, those run about 10 years, and that may expire, and you may get a new order for one immediately thereafter. But again, you will never have more than one bankruptcy at a time. And wage assignments, again, those really depend on the entity. If they're voluntary wage assignments, there are no limits to those either. And voluntary wage assignments really get treated just like any other deduction that an employee might have, such as a tool deduction, a medical deduction. If the employee's got money left in their check after everything else has been taken, you can take whatever you need to for that wage assignment, which could potentially give them a zero check at the end of it. When an employee terminates, do I still collect for the order from their last paycheck? This is a really great item because this does create a lot of confusion for people. What you want to look at is your employee's exact termination date. And then you need to look at where that falls within your pay period, not your check date per se, but the pay period that's actually creating that check date. You need to collect for the order if your termination date is within that next period that you're going to be issuing a check to that employee for, unless it specifically states on the order that you are not to do so. Now, you will get some court orders, some garnishments especially, that may actually have a termination date of their own, or they may state that they're only good for 90 days or 13 weeks or 180 days. You want to read those orders very carefully because that time frame can start on the day that it was signed off by the judge. It may start on the date that you actually receive it, and most of the time those will actually get sent to you by certified mail, so there's a very clear definition of the date. Sometimes it's just simply going to say, keep it for 180 days and then take on it all the way up until the paycheck that includes the 180th day. So you want to make sure and read that information carefully so that you fully understand just what you need to do on that item. And if you can determine what that end date should be or that termination date should be, again, you're just simply going to want to look at your order, compare that, and determine should you or should you not take it on the last paycheck. What types of earnings or paychecks are considered for court orders? Well, as I mentioned a moment ago when we were talking about gross earnings, pretty much anything that the employee is going to earn money on is eligible for consideration. So again, examples of those are going to be anything that's a working hour, because obviously we're going to pay them for that. Holiday worked, regular, overtime, double time, shift premium, piece rate. There's various terms that we all use within our own organization to identify those earnings. If my employee is getting money for it, then I can consider it. Now, if I'm reimbursing them for something, you know, they're using their own car for company purposes and they've turned in an expense report and I'm simply paying them back that expense on their paycheck. Because that's money that they have already put out of their pocket, it is not eligible to be considered to deduct from for the court order. Paychecks work basically the same way. A lot of times we will issue separate paychecks for maybe a vacation or a bonus check or a sales commission check. All of those earnings are subject to review for the court order. You'll want to watch your court orders to determine if there are any restrictions. I can tell you with my experience over the years, there's very few types of paychecks that are ever excluded from consideration. Third-party sick, workers' comp, even in some cases FMLA, all of those earnings that that person is receiving can be considered for court orders. You want to determine, based on the order, if you need to collect for it. If there's an expiration date on the order, is that the exact date to stop it? Or is it stopped on the next paycheck the employee receives after that date? This kind of goes back to what we were speaking to a moment ago with actual termination of an employee. Again, your orders are going to be very specific. If you have questions, just simply call the entity that issued it. But in most cases, when orders have an exact expiration date, it is going to continue to spell out on that order, when do you need to take the last payment for it? More times than not, it is going to be the paycheck that corresponds with that date in question. Can I, as an employer, collect a fee from my employee for any court orders that I'm deducting from their paycheck? Yes. However, there are some exceptions to that, and those are driven by the state or the court order themselves. Federal tax liens do not allow you to collect a fee. Most federal student loans do not allow you to collect a fee. Most bankruptcies do not allow you to collect a fee. Garnishments, such as my employee didn't pay their credit card bill or they owe hospital bills, those, in most cases, can have a fee deducted. It's going to state on the order what that fee can be. And most of you have probably noticed it's an either or. It's either 12% $12 or 3% of the total amount you expect to collect back from it, which then gets divided 50-50 between the employee needing to pay it and you as the employer being able to subtract that from the amounts that you're submitting to the plaintiff for their payment. Now you want to be careful with that because more and more of those are starting to word it to where you cannot even think about collecting the fee on those items until after that balance has been paid 100% in full. And the court or the state, whoever's collecting it, will notify you at the end of that order saying, yes, this has now been paid in full. This is the amount that you can collect. So you want to be careful with those because you don't want to collect for it too soon, but you don't want to miss out on the opportunity to be able to collect your fee as well. Child support orders are specific to the state. The state guidelines will tell you, and most times even in the order, it's generally on page 3. If it's a 4-page order, it'll be on the bottom of page 2. It's a 3-page order. And it's down in the area where it has remittance information, administrative fees. It kind of gets worded a little bit differently just depending upon the state. But it will spell out in there what you're allowed to collect for that. You as a company can always say, I'm going to take $2 for every order, which is fine. Just keep in mind that if the state or the entity that you're collecting for states that you can only collect X amount of dollars, that is all you can collect regardless of what you as a company are determining for your amount. What do I do if I as the employer do not want to handle these types of items for my employees? Is there a way TruPay can take care of all of these? Yes. If you are handling your own court orders right now, and you're reaching out to our support departments, whether you're on Inspire, you're on Millennium, all we can do here at TruPay is simply assist you in setting up the deduction. You will need to understand the order to basically tell us, okay, I've got this amount of information. I'm not quite sure how to put it in the system for the deduction. That is all we can legally assist you with. If you have questions on the orders, you're not understanding it, you're not sure how to interpret it, you're still going to want to reach out to that entity to get clarification from them. The other option you have is our Garnishment Services product, which is the product that I oversee here at TruPay. This process, or this product rather, is something that TruPay offers to all of our clients, regardless of how big or small your employment staff is. What we do in a nutshell is we handle everything for you. We will take care of all those communications. So those interrogatory requests, 2 pages, 20 pages, some as many as 40 pages. We handle that for you. We complete those, disperse them back to the entities that need to have a copy of it, as well as a copy completed to you so that you can have it for your records and provide one to your employee. We take care of all the deduction setups. We take care of setting up all those agency or vendors of whoever think they need to have a payment. Anytime somebody reaches out to you, maybe the plaintiff is not agreeing with the amount of money they received, or the state doesn't like the way we sent the payment or something along that line. If you're part of the Garnishment Services product, simply all you're going to do is give that entity our number here at the office, tell them to call TruPay and ask for the Garnishment Service Department, and then my department will take over and handle all the communications for you. When that employee terminates, we will then take care of also notifying that entity of that termination and completing any of the required paperwork for whatever the order might be the employees had. The only thing that we do not do with the Garnishment Services product is national medical support orders. You will start seeing more and more of those now. A lot of times they're coming with your regular child support order. As I mentioned, child support orders are generally 3 to 4 pages long. Your national medical orders are going to be 6 to 10 pages long. And it's very obvious what they are when you get one. Those are still something that you as the employer will need to handle regardless if you're using TruPay services or not, because they're not technically a court order. It's more of an information gathering based on your health care benefits that you offer to your employees, as well as to determine if, along with the child support deduction that Garnishment Services is handling for you, does an employee really make enough money to pay for the health insurance they might be required to pay? We also, for security reasons, as most of you are already aware, having worked with us through payroll, maybe time, HR, we don't deal directly with your employees. We respect the employee and employer relationship, and we want you to be that main person that they come to. Now, of course, if what they're asking or looking for is not something that you are familiar with, you're not quite sure how to handle it, you, of course, will reach back here to the Garnishment Service Department, and we will be happy to assist you. The long and short of it is we take a big headache off of your shoulders. In some cases, it may be a huge amount of time that you are spending in your organization. If you are a one person that's handling everything from your payroll to your HR to your benefits, this can be a big amount of time that you spend on handling these things, and that is what Garnishment Services is here to assist you with and to help you with. If you're interested in any of those services, please do not hesitate to reach out to TruPay. We will be happy to go over any of that with you. Of course, you can reach out to me direct, or you can reach out to anybody in our sales department as well. But that is a service that we offer to all of our clients, again, no matter how big or small you are. And we encourage you to, if you want, explore more about it. I want to thank everybody for your time this afternoon. And again, I respect that our afternoons are always busy, so I truly appreciate all of you joining us this afternoon. As I mentioned initially, we are recording this session. We will be posting the recorded session out to our websites as various other links that we use. We will be compiling the questions as well as the ones that we've used here today in our demonstration or webcast. And I will be answering all of those again and providing that information back out to you. Of course, if questions arise at a later time frame, always feel free to reach out to TruPay and we will assist you in any way that we can. I want to thank everybody for joining us this afternoon, and I hope you have a wonderful afternoon. Thank you.
Thanks again, everybody, for joining us. I want to let the people know we did have several people who submitted questions. Thank you for those. Julie will be following up with you personally to give you detailed answers to your questions. I want to let you know we have received them, and we will be responding to those in person. Also, as Julie mentioned, we're going to make this webcast available on a web page. I'll be sending everyone the link to that web page here in the next couple of days as soon as I get it built. And as always, if we can ever be of service, you ever have any questions, we're just a phone call or an email away. Don't hesitate to get a hold of us. Thanks again for joining us, and keep an eye out for our next webcast. It's coming soon. Thanks, everybody.